Hello, everybody. Hi, Ava. Hi, Bandit.
All right, the court will call the case of the Ranches of Rosebrook versus A Nice Battle, case number 25C 1245.
Good afternoon, Your Honor. David Fanter on behalf of the plaintiff.
Ms. Battle, please hit *6, unmute your device and state.
Hello? Hello?
Please state.
It's a niece battle on a special appearance for the record to contest the jurisdiction and the facts before this court.
Yep. All right. Well, Ms. Battle, I'll tell you that this matter is appropriately in the correct court. The court does have jurisdiction.
And that's based on what? What is on the record that is based on that the court has jurisdiction?
The fact that this is a case that is within the jurisdiction of the Township of Ypsilanti, and if you have issues related to any contracts, that would be within this jurisdiction as well. So all of that is within the jurisdiction of this court.
So you're saying that the contract is in jurisdiction of the court?
That is what I just said, ma'am.
All right, and the contract has been rescinded. So how is the contract in the jurisdiction of the court if it's invalid?
Well, gets to rescind a contract on their own. That's
what are you talking about? I have the right to rescind a contract by right of common law.
Ms. Battle,
that doesn't involve court.
Ma'am, you need to stop talking or you're going to get held in contempt of court. Mr. Fantier, have you had a chance to talk to Ms. Battle? Talk to Ms.
You're breaking up. I can't hear you.
Mr. Fantera, do you need to speak with her, or are we ready to...
If you want me to speak to her, I'll speak to her. You know, I mean, she talks about rescinding the contract. Does that mean she's moving out?
I'm sorry, you're breaking up.
Are you moving out?
Are you moving out?
No. Why would I have to move out?
Because if you rescind a contract, okay, fine. Your Honor, I think we just set this for trial.
Okay. One moment.
This case has also been in the it's in the circuit court. A petition filed for an injunction. I did serve you all. It is set on the 30th.
Yes, ma'am. I heard.
We're aware.
Okay. And once again, I do not submit to the jurisdiction of the court. The contract is rescinded.
So how can the contract?
And I am not a legal person.
You're not a legal person?
How can a contract? No, I'm not a legal person. I'm not a legal entity. No, I am not. And you have to prove that on the record.
Actually, I don't.
I'm sorry.
Can I ask Ms. Battle a question, Your Honor, real quick?
Sure.
So, Ms. Battle, so you can live there forever without paying rent because you're not a legal person?
That's not what I'm saying, but the contract itself is invalid. I'm saying that you don't have any personal or subject matter jurisdiction over me. Over an invalid contract, no. And over me not having a legal capacity to be sued, yes. So if that's how you want to take it, then that's how you have to take it. But that's what's lawful, and that's what's written in the law.
Let me just tell you, I think you're wrong on both counts. I would expect that we would.
It's okay for you to think that I'm wrong, but the facts still align with what I'm saying.
Okay, Your Honor, I think we should have a trial.
You have to prove without the reasonable doubt. So let the record show that the judge has not required the plaintiff to prove without a reasonable doubt that I am a legal person, and it's on the record, not assumed, not presumed, on the record. There's nothing that's on the record that states.
Ms. Battle, first of all, reasonable doubt is a standard in a criminal case, not a civil case. So I do not have to prove anything beyond a reasonable doubt.
I need both of you to stop talking, please. Both of you, I'm sorry. I cannot figure out the date because I can't hear over the two of you.
I apologize. I didn't know that's what you were doing, Your Honor.
All right, Mr. Fantera, are you available on May 6th at 3, you said? At 3 p.m. for trial?
What's that, a Tuesday?
Correct.
Yes.
All right. This matter will be scheduled for May 6th at 3 p.m. for a trial on any and all issues that may be before the court. Ms. Battle, if you have anything else that you need to say, you can unmute yourself by hitting *6 to do that.
Okay, I just find it ironic that I got muted when I was speaking on jurisdiction and how there was a lack thereof on the record. So I want that to be on the record. But I also wanted to, okay, that's fine. And I also wanted to be on the record that I am not going to be able to show up on May the 6th. So it's also ironic that you are able to verify with him that he's able to show up and not with myself.
I just asked you that, and you are now talking about something else. Why can't you do this?
That's because you cut me off and put me inside of a break room and muted my mic instead of allowing me to speak on what needs to be spoken on.
All right, this is set for May 6th at 3.
Your Honor, by Zoom? By Zoom?
Correct.
All right. Thank you, Your Honor.
It's ridiculous. This is a fraud upon the court. Goodbye.
The court will call the matter of Peter Jordan versus Frederick Reed, case number 25C 1193.
Good afternoon, Your Honor. I'm Peter Jordan.
Good afternoon, Mr. Jordan.
Good afternoon, I'm Frederick Reed.
Thank you. Good afternoon, Mr. Reed. All right, we're here for the third hearing because last week we had to get adjourned because of a Zoom issue. Mr. Jordan, have you had a chance to talk to Mr. Reed, and do we know where we are at this time?
Yes, we were speaking this morning and we have agreed to a conditional dismissal, which we have signed and emailed to the court.
Thank you. It appears here that the rent in this matter is $6,630. The court costs $155 for a total of $6,785. Is that correct, Mr. Reed?
Sounds about right. We have some other conditions that needs to be looked over.
I'm gonna list those conditions in a second, but what I need to find out now, sir, is you have a right to have a hearing as to the amount that is owed. So I'm trying to find out if you agree to the amount that is owed or not.
No, but I do agree on what me and Peter, but I don't agree on the amount that's owed, no.
Mr. Jordan, he's saying he doesn't agree that he owes you $6,785.
But me and Mr. Jordan can work that out.
Okay, so the agreement is that he's gonna move,
That's correct, Your Honor.
and if there is any disagreement over the amount, that would be taken up in a different action. Is that what you're saying?
Mm,
That's
For
an
me?
option for us, Your Honor.
I'm sorry, what did you say? Jordan, what did you say?
I said that is an option for us, yes.
Your Honor,
Yes.
my concern is that the way that is worded, this was a foreclosure, and it was my father's home. And it's never been inspected. So it says in there that further damages to home and forth. I don't think he knows what damages is there, or what's working and not working in the home. I do worry that that there may be something said that was damaged that's not damaged. This home hasn't been. This was the home that I grew up in. It was my father's home. It says things in the lease that the home needs to be swept in condition. Well, I have a worry about being responsible for some of my father's things that was here. But I do feel that me and Mr. Jordan can work this out without this going in trial, but because I think that we both would like that to happen. But I would like to be fair to the estate of Frederick Reed to assume some of the proper condition that the home was in when we made the thing. But there's no thing to say what was damaged and what was not damaged. And then I would like to, out of honor of my father, to pass some of these things, his belongings away. But there's some things, the pool table, there's things that I'm not capable of throwing away. So but I would like to do this in a way where it works for Mr. Jordan and myself, and being fair for all parties involved.
I'm not looking to pursue him for items left behind, charges for items left behind, Your Honor. That would be a separate matter anyways. But
Okay.
that's not my intent. My intent is to get him a dumpster so he can take what he wants and leave what he wants.
Thank you. Thank you for that. Thank
You're
you.
welcome.
So let me finish reading this conditional order of dismissal. It says that the defendant shall provide possession of Avenue on May 12th. The defendant will provide a forwarding address on or before 4 days of terminating the occupancy.
I worry about that one too, but I think that me and Peter could work that out. So I do worry about that one too, but
So I don't know what you mean by these things when you're saying you can work them out. These are the agreements that you're reaching as of today. So,
well, as of today, I don't have a forwarding address, but I will though. See, I'm able to get myself a new place, and it was very difficult to do with a judgment. So I have good credit, and I do have the means to get myself a place. And so I don't think me moving out would be a deal. I wish it didn't say within 4 days though, because but I think that me and Peter could work this out. But I don't know about within 4 days, because that's what, 2 weeks away. But
Mr. Reed, Mr. Reed, are you done talking? Because I was talking and you just talked over.
I'm sorry.
Okay. So what I was saying before you cut me off was whatever you have in writing here is what your agreement is. That's the way this works. So if it doesn't work out, then you're in violation of the agreement. Do you understand that part?
I think I'll be good.
Okay. Defendant shall pay $480 on May 2nd, 2025, $500 on May 16th, 2025, and then $500 monthly on the 16th of the month commencing June 16th, 2025. For how long, Mr. Jordan?
Until the balance is paid, Your Honor.
But he's not even agreeing to the balance. I don't know how the two of you have an agreement.
I think Mr. Reed's concern is that I had told him that if he had receipts for items he had done to the house, that I would take that off the rent owed.
Mhm.
I think that was his,
But you didn't put that in the agreement.
we can add it to the agreement if you like, Your Honor.
Yeah, I would like. Is that correct, sir? So if you have receipts, he's
Mhm.
gonna take that off the balance owed, that would make this, then you.
Yes. And I just wanted to be fair with him, to give him time to look at it. But I've had medical conditions, and I apologize. I don't want to show myself my face, but I just wanted to give him a chance to review it, and us be able to come to an agreement on those expenses. Yes. But
Receipts, so what type of expenses are we talking about?
what expenses? Tree removal. There was multiple storms. I had to remove trees. The septic. I had to pay to get snaked a few times. I would say is in the range of between $1,500 to $2,200.
Your Honor, I've asked him for the receipts, but he has not been able to locate the receipts yet.
Oh, I have the receipts from Cash App. The
All
problem
right,
has
all right.
been,
Thank you. I understand that you haven't seen them yet. I have written in here, if defendant provides receipts for expenses at the home, plaintiff will provide credit to defendant or have hearing before the court if there's a dispute. Okay?
Mhm.
Yes, Your Honor.
All right. Now, sir, you're waiving your right to have a hearing on the $6,785 that's owed.
Yes, yes, yes. There was one more thing with the dumpster. I would like that in agreement, please.
Oh, that I'd provide a dumpster at my expense, Your Honor.
Plaintiff to provide dumpster at plaintiff expense. Okay, I've added that as well. All right, given everything you've told me here, I find that this is fair. I will sign, sir, and you will not have a judgment on your record as long as you comply with the terms of the agreement, okay?
Thank you. Thank you, Peter.
Yeah, you're welcome, Mr. Reed. Thank you, Your Honor.
We have 3 business days from the date that I signed this, sir, to petition the court to set a decisive good cause. You're all set. Have a good day.
So thank you.
Bye-bye.
You too, Your Honor.
Village Grove 1 LLC versus Ashley Armstrong, 25C 1198.
Good afternoon, Your Honor. Michael Burns, P87855 on behalf of plaintiff.
Good afternoon. Is Ashley Armstrong present? Please unmute your device, state your name. Ashley Armstrong, please unmute your device and state your name. Want to pass that one too?
Thank you, Your Honor.
Village Grove 1 LLC versus Cecilia Augustine, 25C 1199.
Good afternoon, Your Honor. Michael Burns, P87855 on behalf of plaintiff.
Hello, Cecilia Augustine.
Excellent. One word. All right. We're here in our 3rd hearing for non-payment of rent.
Yes, Your Honor.
Actually,
Oh,
second
I'm sorry.
one because the first one didn't happen. Have you guys reached an agreement in this one?
Yes, Your Honor. Parties agreed to a consent judgment, and I can place the terms on the record whenever the court's ready.
Right, one moment. Yeah.
Okay, I'm just making sure because Ms. Armstrong started her video and unmuted, so I've now remuted her, so as to not have it interrupted.
Okay. All right, you may proceed.
Thank you, Your Honor. There's currently a total due and owing of rent of $2,528. Costs in the total of $175 for a total of $2,703. Ms. Augustine informed me that she had applied for assistance but was denied. Nonetheless, parties had agreed to a consent judgment with the terms that that total due and owing would be paid on or before May 5th, 2025. Otherwise, a writ may issue. No money judgment would be entered at this time. MCR 4.201J was explained to Ms. Augustine, and she agreed to allow me to sign her name to the judgment, Your Honor.
All right. Ms. Augustine, ma'am, you understand you have a right to have a hearing as to the amount that's owed.
Yes,
You're going to waive your right to have that hearing and agree that you owe $2,703 and that you
Yes.
do that no later than May 5th of 2025, correct?
Correct.
And you understand if you fail to pay this, then it will, they will come in here and ask for a writ evicting you from your home, giving you only 24 hours notice to move. Do you understand that?
Yes.
I will sign this agreement. I do request, Mr. Burns, that you guys do a set aside if she pays it.
Yes, Your Honor.
So if you pay it, ma'am, you won't have a judgment on your record. If you don't pay it, you'll have a judgment on your record and they'll request a writ to evict you. You understand, ma'am?
Yep.
All
Sounds
right.
good.
Have a good day.
Thank you. You too.
Do we have anything else ready?
Ms. Armstrong did it.
Oh, Ms. Armstrong, turn on the camera.
So
Yes.
we wanted to try to call that.
Let me try that. All right, Village Grow One LLC versus Ashley Armstrong, 25C 1198. This is a recall.
Armstrong.
I'm here, Your Honor. Michael Burns, P 87855 for plaintiff.
All right, this matter was adjourned from last week to today's date because of the Zoom outage. Have the two of you had a chance to talk?
Yes, we have, Your Honor, and parties agreed to a consent judgment.
All right, you may proceed.
Your Honor, there is currently a rent to retain of $942, costing the total of $175 for a total of $1,117. Ms. Armstrong and plaintiff agreed that that amount would be paid on or before May 5th, 2025. No money judgment is entered at this time. MCR 4.201J was explained to Ms. Armstrong, and she gave me permission to sign her name to the consent judgment.
Thank you. All right, ma'am, you understand you have a right to have a hearing as to the amount that is owed. Are you agreeing that you owe $1,117?
Yes, I am.
And you're gonna pay that no later than May 5th, 2025, correct?
Yes, ma'am.
All right, if it is paid, then the judgment will be set aside. If it is not paid, then they're gonna come in here and ask that I issue an immediate writ, giving you only 24 hours notice to move, okay?
Okay.
And then you'll have 3 business days from the date that I sign this, which is today, to petition a court to set it aside for a good reason, okay? But it's rare that I do that. All
Okay,
right?
thank you.
You're all set. Have a good day.
You too. Bye-bye.
Thank you guys so much for coming out and spending time with me. I love every one of you. Be safe, be well, sleep sweet, and much love.